Good afternoon, Your Honor. Daniel Magoo.
All right. Mr. Gu, you are representing yourself. I do have to apprise you that you are before the court on charge of resisting and obstructing a police officer. That is a high court misdemeanor, or what technically is known as a high court misdemeanor, and or felony punishable by up to 2 years, $2,000 fine plus court costs. There are great perils in representing yourself. In this, you have to understand that I am going to treat you the same as though you know the laws and the rules of evidence. I will not treat you worse because you are not represented. I will not treat you better or grant any favors or try to clarify anything for you. If, for whatever reason, during any point in this proceeding, you wish to be represented by counsel and cannot afford to hire counsel, counsel will be appointed to represent you. As I have in the past hearings asked you to acknowledge what I've said, I'm going to only indicate that I believe that you understand English. You believe that the words that I have said to you are understood, so that we don't get into, you need to remove the gum from your mouth.
Mr. Mio is back, and this time, he's about to learn the hard way just how important legal representation really is. If you're new here, this is actually part 2 of a previous video we posted not too long ago. For a quick recap, Daniel Mio is, frankly, a disaster in the courtroom. He dodges Judge Simpson's questions, carries himself with an odd sense of superiority, and acts like the rules simply don't apply to him. And as you're about to see, things go downhill almost immediately. Even saying his name feels a bit unusual, but what's more surprising is his behavior. At one point, he's literally sitting in court chewing gum, without a lawyer, and showing zero awareness of how serious the situation is. Let me be clear. This is not how you handle a court case. Having proper legal representation isn't optional, it's essential. Mr. Mio is a perfect example of what not to do. Anyway, enough setup, let's jump in and see how this plays out in court.
And
Thank you.
so I will not ask you to acknowledge. I will presume that you do indeed understand everything that I've said. Now, having said that, what are we doing with this case?
I'd like to move for evidentiary hearing or a
You wish to have a preliminary examination?
preliminary examination. Yes, sir.
Would the people have their witnesses available the second?
We can try, Your Honor, but before moving toward that, would the court be willing to make its inquiries about discovery? I am aware of the defendant having filed a writ of mandamus with the Court of Appeals for the state of Michigan.
Yes.
That was subsequently dismissed without prejudice by the Court of Appeals.
Correct.
Contained within that, though, there are allegations that my office has violated its Brady obligations and has not provided sufficient discovery. So I'm not sure if we're ready to move forward to preliminary exam. The defendant is saying that he doesn't have all of the discovery. That is the concern. The record I feel compelled to make at this time, though, is that the people have provided, I do believe, complete discovery to the defendant, and I believe that some of the representations that were made in this writ of mandamus that has been dismissed appear to allege that things that have already been denied by this court should be produced. Furthermore, the defendant filed a motion with no notice of hearing attached to it. So there's an outstanding motion in this case as well, no hearing date scheduled. So I'm hoping that we can sort of reconcile both of those things as whether or not discovery is something the defendant's prepared to move forward, and if he ever intends to file a notice of hearing to go along with the motion that I received in this case on 11/22.
Mr. Magoo, your response?
My response is that I thought this was the hearing that we were setting for the motion. So if I have to set a motion for a notice of hearing for that motion, I will do that today, Your Honor, promptly.
What about discovery?
I'm ready to move forward on my what I meant by my discovery comment was that there's still no exculpatory evidence as far as that I did anything wrong as far as anything that they've submitted. So it was improper for the wording, Your Honor, I apologize, but my ultimate goal is have the prosecution present their evidence against me.
I'm going to indicate discovery is complete because I don't know what you're saying, because what you just said regarding discovery didn't make any sense. As it regards the motion, we will hear the motion the motion will be heard on date of exam.
Thank you, Your Honor.
Deal with it at that point in time. So the people would have their witnesses available on the second.
We can try for the second, Your Honor.
Preliminary examination in person, January 2nd, 2025, 12.
Yeah.
12 noon, that is before me.
Thank you, Your Honor.
And continue.
This guy is the definition of why legal representation is so important. Not only does he come completely unprepared, but he also has this incredibly smug attitude, like he genuinely believes he can outsmart the judge. Honestly, I don't know what gave him that idea. If anyone watching has a theory about why he's acting like this, let me know, because it doesn't make much sense. To me, he comes across like a sovereign citizen. And if you've seen my other videos, you know how that usually goes. They tend to act like they're above the law, the court, and even basic reasoning. It's baffling. What makes this even more serious is the fact that he's in court for assaulting a police officer, a major charge. On top of that, he's already lost custody of his child, which says a lot about how serious his situation really is. And yet, here he is, treating it like it's no big deal. Chewing gum, showing no remorse, and refusing to cooperate or build any real defense. He claims he's innocent, but doesn't take any SD.